Honorable Sangon, good morning.
Good morning, Chairperson. Good morning, honorable members. Good morning, colleagues.
Good morning, Honorable Ngola.
Good morning, Chair.
Honorable Sokanyile.
Morning, Chairperson.
Honorable Nombal.
Morning, Chair.
Honorable Skosana.
Ngiyakulochisa mgcinisihlalo ngilochisa lesitshaba namalunga weParliament ephezulu. Ngiyathokoza.
Honorable Matthews.
Good morning, Chair.
Honorable Sols.
Good morning, Chairperson.
Honorable Chopper.
Good morning, Chair.
Honorable Vessels.
Good morning, Chair.
Advocate RNC, good morning.
Good morning, Honorable Chair, Honorable members, and all those present, Mr. Mashuga and his team. But my colleagues are both busy with other witnesses. If they may be excused, Honorable Chair.
Okay. Good morning to our witness, Advocate Mashuga.
Let me help.
You are extreme right. Right, extreme right.
Good morning, Chairperson. Thank you.
Is it Mashuga or Mashuga?
Shuha.
Okay. And Advocate Maka, good morning.
Good morning, Chairperson, and good morning to the honorable members of the committee. Thank you.
And pass our regards to your colleague and introduce him.
Good morning, Chair. Good morning, members of the committee. My name is Apla. My surname is Bodlani. Thank you.
What's her name?
Bodlani, Bodlani.
Oh, Botlane. Okay. Mr. Chetty, good morning. Mr. Chetty, good morning.
Morning.
Thank you so much. Good morning to the staff of Parliament, Mr. Tejana, Dr. Tuli.
Good morning, Chair.
Mr. Pilot Kwebu, good morning. Honorable Kola Barnard, good morning.
Good morning to you, Chair.
Thank you so much. The staff of the political caucuses in the National Assembly, good morning to you. Thank you so much. Do we have apologies, honorable members? Can we start with the African National Congress?
Thank you very much, Honorable Chairperson. We've got an apology from the Chief Whip. He will join us during some time in the day. He's engaged at the Chiefs Forum. Thank you.
Okay. MKP.
Thank you, Chair. Honorable Shonge will join us later at lunchtime.
The DA.
Thank you, Chairperson. I think you have received the apology from Honorable Breitenbach. And Honorable Cameron is chairing a meeting now. He may be finished by lunchtime and will then join us. And I have to leave for about half an hour just before 1 o'clock, but I will come straight back. Thank you, Chair.
What is the apology of Honorable Breitenbach?
She has had to fly to Johannesburg, I believe. I'm not sure which province, but she
will
was
not be able
needed urgently there. I beg your pardon?
She will not be able to join today's.
She will not be able to attend at all for the rest of the week. Thank you.
And then when you say you have to leave, where are you going?
I have another parliamentary commitment for half an hour on another committee.
Thank you so much. Any apologies, Honorable Sols?
No apologies, Chair.
Honorable Vessels?
Thank you, Chairperson. I'll just have to step out at 12:30 for a Manco meeting, and then I have a meeting with the House Chairperson Frolic at 1:30. And then this evening, I'll see, but I might have to attend the joint committee on financial management of Parliament. Thank you, Chair.
Okay. The committee which I'm the co-chairperson. Okay, yeah, we have a meeting tonight. Do we have the apology from Honorable James Mkhwanazi? Okay. Honorable Mnwango is also here just by the door. He's concluding another commitment. Before we start, this morning we woke up to the sad news of the passing away of the former member of this Parliament, both the National Assembly and the National Council of Provinces, Musiwa Teralakota, a former leader of the United Democratic Front, a former leader of the African National Congress in the Free State and former premier, the inaugural premier of the Free State Province, and former chairperson of the National Council of Provinces, the former national chairperson of the ANC, and the former member of this National Assembly, and the leader of the Congress of the People. Can we rotate political parties to express short messages of condolences to the family?
Thank you. Thank you very much, Honorable Chairperson. On behalf of the African National Congress, we'd like to express our sincere condolences to the family of Comrade Terra Lekota. We also extend condolences to his party, the Congress of the People. I think as the ANC, we will always hold Mr. Lekota in very high regard for the role he played, not only in the African National Congress, but also in the struggle for the liberation of Blacks in general, Africans in particular of this country. So we mourn with them and wish them strength during this difficult time of bereavement. Thank you, Chair.
The MKP.
No, thank you very much, Chair. We wish to convey our deepest condolences to the Lekota family and to his political family, Congress of the People. Those who speak well usually say there's only one day we do not know, and usuku lokuhamba emhlabeni. So we are saying God has taken what belongs to him. Abalale ngenxeba, alihlanga lungehlanga. Thank you very much.
Honorable Kola Barnett.
Thank you, Chairperson. Yes, I served along at the same period as Monsieur Lekota. I've been here since 2004, and I have had the deepest respect for him, having heard, sorry, Chair, having heard his speeches on the podium. He was at times positively presidential. And I think a man who will be greatly missed. He's missed in Parliament. He's greatly missed, I am sure, by his family. And I proffer our deepest condolences. I literally have marched alongside him for the protection of farmers and the like. I've got to know him extremely well. And I think he will be greatly missed, and my deepest condolences to his family. Thank you.
Honorable Matthys.
Thank you, Chair. And on behalf of the Economic Freedom Fighters, we do send our revolutionary condolences to a freedom fighter and someone that has also spent a large part of his life in prison and on Robben Island. And we appreciate his contribution that has brought us all here to be able to sit here in Parliament. And may his spirit live on and in us, his fighting spirit. Thank you, Chair.
Honorable Swals.
Thank you, Chairperson. On behalf of our President, His Excellency Gayton McKenzie, our Deputy President, the Honorable Kenny Kunene, the entire Patriotic Alliance South Africa, we want to extend our deepest and sincerest condolences to the Lekota family, and want to share a scripture that says, "Blessed are those who mourn, for they shall be comforted." So may God comfort the family. And like we say in our communities, Resach Rodman. Salute.
Honorable Vessels.
Thank you, Chairperson. Also on behalf of the Freedom Front Plus, I wish to convey our deepest and sincerest condolences with the family of Mr. Lekota, also with his friends and with his political colleagues in the Congress of the People, COPE, which he started. I think that Chair, one could have differed from him, but there's one thing that nobody can deny, and that is that Mr. Lekota always treated everybody with respect, and that he made a huge contribution to South Africa, to democracy, and also to opposition politics in South Africa. He started an initiative called, which was called at that stage, the Collective for Democracy, where myself and him worked closely together in 2012, 2013, around that time. And I got to know him quite well, and yeah, our deepest condolences. He made a huge contribution and he will be missed. Thank you, Chair.
Honorable members, thank you so much for your commiserations with the family on their loss. I hope that they are following these proceedings, or a relative or a neighbor is hearing your commiserations, and they will be able to pass them on to the family. Indeed, it's true, Honorable Nomvalo, what you said in Sesotho, Atlala ipya madiba, ago madiba sa piyo, le shokal setlefala re lebeletse. Honorable Skosana will help to give you to give you the context. Yeah, he will give you the transcript. Mr. Ramano, you said when you gave the apology of Honorable James, your microphone was not on, and that might not have gone into the record. Can we please make sure that it goes onto the record?
Thank you, Chair. The apologies that she is currently in another meeting and she will join us as soon as she's done in that other committee. Thank you, Chair.
Thank you so much. Your hand is up, Honorable Skosana.
Thank you, Chair. I'm sorry, it's just I have to raise this, and I think it's the right platform, or perhaps others will say it's the wrong platform. Chair, our core committee, for me, I'm not happy for, but all these excuses which are made here, all these apologies. Because if we all apologize, Chair, because we've got core committee meetings as well, but we are here. It's unacceptable. I mean, people knows that we have an ad hoc committee here. Now, if they don't want to participate, let's close this thing and go back to our committees. Because for me, it's shocking. It's shocking, really. Every day, people are having meetings. I have to leave. I have to do that. It's unacceptable, Chair. It's not fair for you to chair a committee which is dysfunctional.
Yeah.
You know, but really, because you can imagine all these members, if we all have to send you apologies, what's going to happen to this committee? And we have the last extension now. We know that there's other issues. People should delegate on other issues. Hence, we have alternative members. Even if you are a chair, you said you are a co-chair in another committee, but we are here. Now, if one has to say, what am I going to prioritize? I'll say I'm going to Scopa. or I'm going to international relation. It's not fair. It's not fair for South Africans. It's not fair for us as members as well. That we have to be here to form a quorum. Now we have to count ourselves. How many are we? Because we can do the same thing. We can lobby Honorable Ngola and Sangoni and say, and Mateis, and say, let's not come. Let's make an excuse and go to our committees. It's not fair, Chair. My last point was, I thought yesterday, Chair, we said we're going to start with the public participation because I think we're going to need a lot of time with the advocate. Masha, but I'm not sure whether that has changed because we said maybe, if I remember well, I might be wrong, maybe we'll have a public participation until lunchtime because there's no leading evidence. I think he's going to present himself. You heard, I'm not sure whether Mr. Chetty or is the, yeah, or whoever, you know, but I don't know. It's your discretion, but I thought that's going to be like that because the last time we had somebody here waiting for hours and hours. You know, maybe it's not going to take time. I don't know, but we are under your leadership. Thank you, Chair.
It's not my discretion. The chair executes the committee's decisions. My understanding is your understanding, Honorable Skosana. I think the legal team will lead us. We said that Advocate Mashucha, we are going to start with Mr. Chetty. There is nothing wrong with you sitting together there. He will just come and sit there and make a presentation for about 45 minutes to 1 hour. And the committee will determine how it moves forward with his presentation. Is how we agreed yesterday. Immediately after his presentation is going to be you. But it does not mean you must move. Just sit there. That is the code of good neighborliness. Honorable Sols, do you have a point you want to raise? Yes, the floor is yours, Honorable Member.
Thank you very much, Chairperson. Chair, I'm a bit concerned. Already, you know that I have an issue with the restricted time allocated to us when we have to question witnesses. Now, of course, we have now decided that, you know, we're going to stick to the time that you give us, which I understand, and we go through that. But when we are restricted in that way, and we are allowed another opportunity to ask a question or get clarity, we should be allowed to finish that. And I'll tell you why, Chairperson. Yesterday, with a general that was here as our witness, on the opportunity you gave me for clarity, you then cut me off, and there was something material I wanted to state for the record. It is not about the exchange, because this exercise is for evidence. So it's important what we state for the record. So I missed that opportunity, but out of respect to you, I stepped back. Upon reflection, I thought it is important that I bring it to you because it's not about the time, it's about what is important to be stated for the record. So I would like to state that for the record so that we have it. And then there's one more issue around the witnesses for public participation that you said yesterday towards the end of the meeting, the 2 witnesses for public participation that we have agreed as a committee already, that they are going to appear before us, that their statements will be referred to legal to decide, whereas the committee has already decided. And I think it's the responsibility of the legal team to assist the public if the presentations is not clear. But when I read the affidavits yesterday, I saw, although it was done in their way, in their informal way, material issues that we should allow them to ventilate here as it relates to interference. It was a murder case, and they are claiming, or there's allegations that they have not been, there's been interference and defeating the ends of justice by the South African Police Service. I think we should hear that, even if we hear it in a way that they give it.
Yeah.
So that's an issue. I'd leave that there. May I state for the record what I wanted to state yesterday when I was cut off, Chairperson? Is it okay? So yesterday, the two statements, the material difference in the two statements made under oath by General Musikili of the macro incident. The material difference is the crime scene. On the one statement, she says that her belongings was stolen inside of macro. In the other statement, she says that her belongings was stolen.
Point of order, Chair, please.
In the car.
Point of order, Chair.
In the car. So that is the material difference.
Point of order, Chair.
In the two statements.
Just hold for a moment, Honorable Souls. Let's hear the point of order from Honorable Skhosana.
Chair, I don't think it's fair that we are discussing what happened yesterday here, because the witness is no longer here. We'll discuss that internally. We can't be discussing the statement today when we had an opportunity, even if some of us might not be happy with other issues. But we can't be discussing a General Musikili issue now. To say, I can raise something as well, that I was not happy with this. So I'm saying, please, Chair, let's focus on the witnesses which are before us now. Thank you, Chair.
No, I hear the point of order that you are saying. And all of us are well aware that General Musikili is not here today. I don't think the honorable member is raising the point to say we must discuss it. The honorable member is bringing the matter to our attention, and let's allow him to conclude his point. And if it's a point that we must refer to the legal team, we will do so, but let's allow him to raise that point. I think it's only fair that we hear him. Honorable Souls, may you please conclude?
Thank you, Chairperson, and thanks for understanding. It's for the purpose of the record, so that when we consider the testimony, this part is part of that record for consideration. So the material difference in the two statements, the General testified that it was the same statement and the content of the statements are the same. And I put it to her that it was not the same, and the difference is the scene of crime. On one statement, she says her belongings were stolen in macro. On the second statement, she says her belongings were stolen at the gate outside of macro. And that is the material difference. Okay. Thank you, Chair.
Yeah, what we will do for the purposes of fairness and to justify our actions, we are going to request you that you put that in writing. And through the legal team, we pass the statement to the witness, so that if there is anything that you may want her to explain, let her explain that, so that we don't become one-sided. Honorable Nomvalo.
Yeah, no, thanks, Chair. But I thought those are the issues that are relevant for our deliberations. Because during the deliberations, when we're done with the interviews, we are going to expose the discrepancies that we have detected during the oral and in the written statements. So I don't think it's relevant for this meeting. And Honorable Skhosana was correct, Chair, to say those are the issues that Honorable Souls is supposed to keep and raise them when we deliberate, to say this witness was not credible on this basis because his statement was contradictory and so on and so forth. So that is my understanding, Chairperson.
Yeah.
Yeah.
No, you are not wrong in your understanding. Let me tell you, both you and Honorable Sols are not wrong. Honorable Sols is raising a matter here, which the chair says, let's put it in writing, so that the witness can also be given an opportunity to respond to it. It will come to deliberations. At the time we deliberate, we would have heard the question that Honorable Sols has sent to the witness, and we will also be having the response that the witness would have given us. It's unlike when we reach a point of deliberations and then he raises the matter at that time, and somebody stands up and say, no, but the witness is not here, has not been given an opportunity to respond. I think let's take it in that spirit, honorable members, that it will be passed on to the witness, and the witness will also be given sufficient time to respond to the question that Honorable Sol is stating here. And with regard to your request, Honorable Sols, about where time expires, and you were asking a clarity-seeking question or a follow-up. Can we agree that the chair will allocate each speaker no more than 2 minutes in case we find ourselves in a situation like that? Is it agreeable? Thank you so much. I'm just saying that we must mind those time lapses so that when your time expires and then maybe the speaker or the witness has not finished responding to the question, we say the chair's benevolence must be stretched to no more than 2 minutes. Is that what we are saying? Agreed? Okay. Honorable Sangon, is your hand up?
No, you've covered me in the summary and the earlier discussion. Thank you, Chair.
Okay, thank you so much. Advocate Mkhize, I want to hear you speak regarding the matter of Mr. Chetty and Advocate Mashale. Which witness do we take first?
Chair, we had prepared with the witnesses that we would deal with Mr. Mashale's evidence first and thereafter Mr. Chetty. That is the team.
We said we were going to give Mr. Chetty 45 minutes to present.
Indeed, Chair. Chair, we are in your hands in terms of guidance, but
I want to check with yourselves and Mr. Chetty if you are ready that we can start with him.
Mr. Chetty and I have not had an opportunity yet to just go through some of his evidence, and that's the reason why we were asking for Mr. Mashale to go first.
Okay.
Yeah.
Okay. We can't go against your advice. If that is so, are you comfortable with that, Mr. Chetty?
Honorable Chair, yes, I am.
Okay.
Thank you.
Can I check, are there any statements you want to make before we swear the witness?
No, Chair, there's no statement we'd like to make. As soon as you've sworn in the witness, if you may please just excuse me so I have an opportunity with Mr. Chetty before we start. Once you've sworn Mr. Mashale in.
Once we say Mr. Advocate Mashale, is Advocate Mashale, is it Advocate or Mr.?
Indeed, so.
Advocate, yeah. Once we say Advocate Mashale in, you request to be released to finalize with Mr. Chetty.
Indeed.
Thank you so much. No, that is granted.
Thank you.
Advocate Mashale, we are going through the swearing in process. Let me just make this remarks before we say you in that you have been invited before this ad hoc committee which is investigating the allegations that have been made, or before.
Chairperson, I stand to be corrected. I have had, I've consulted with my leader, and he's also of the view that perhaps the public participant should go first because his time is limited and it's 45 minutes, and then thereafter we will take the main witness. Okay.
What do you want us to do?
Sorry, Chair, honorable members. I had requested at the last committee meeting to start with Advocate Masha at his request and that of his legal team. I had then asked to be excused from the meeting. So I didn't hear subsequently that that request wasn't granted or refused, or what the position was and the order of witnesses. And that is why, after consulting with Advocate Masha and his team since yesterday, we were under the impression that we are starting first. And I think we still have Mr. Adams on our witness list for today. But in the event that Chair, the public participation witness, Mr. Chetty, are you going to restrict him to time? It may be best in the circumstances. Otherwise, he may well be waiting here, as Honorable Skhosana said, for a long time. And if you can deal with him first, then we wouldn't have any objection.
What is your proposal?
So we propose that he start first, and that Advocate Masha follows.
Honorable Chair, I have not consulted with anyone. There's a lot of evidence that I have that I think council has to see, just instead of reading my affidavit in.
Mr. Chetty, the legal team tells me that they are fine, they can handle your matter. Remember, with public participation, it's not like the witnesses that we have identified. With public participation, they read your statement. They say that they have gone through your statement and they have structured questions, which they will ask you and help you to provide. When they go through your statement, they look at what is relevant to the terms of reference of the committee. You have given us your statement, isn't it?
Honorable Chair, yes, I have. And there's a lot of annexures as well, which I don't know if council has been through it. Because there's a lot of information that has everything to do.
No, it's fine. Let's do this. Advocate Arendse, let's take Advocate Masha for now, so that we do not do with the witness what does not give him or her comfort. If he thinks that on his part, I mean, on the part of the legal team, you may be satisfied that you are ready. So have that moment with him and satisfy him that both parties are ready for presentation. Yeah. Honorable Matthews.
Chair, we've discussed this quite regularly in our working meetings, that our public participants should not be treated any differently than the witnesses that are on our list. And while we made a decision as a committee based on the report that we received from our technical team, there was a process where our legal office is supposed to go through that and treat our witnesses and our public participants with dignity. We can't have our evidence leaders only getting these copies and then just going through it now, Chair. And this thing was even raised yesterday. Why are we doing that? And we've had so many of these issues. That's how we ended up having a witness here, because we brought them here without us just doing basic due diligence on it. Because remember, we made it a decision, Chair, as the ad hoc committee, based on just a report from the technical staff that they went through. None of that was tested. They were not sat down with the evidence leaders. From what I understand yesterday, Advocate Mkhwanazi said they don't have capacity to be able to go through our public participants' sworn statements. So I would have thought that maybe we should see if the Parliament legal team is able to do that, but they're also the ones that don't lead evidence. So I don't think we're doing justice to this process of public participants, and we should not be treating the general public in the manner that we are, Chair. Thank you.
Honorable Nombalo.
Yeah, Chair, mine is a clarity-seeking question. I just need to be clarified on this aspect, Chair. Is Mr. Chetty a witness or a public participant? I'm asking this because I've read his statement, and to a certain extent, he's making a testimony which is within the context of the terms of reference, and a testimony which also involves some institutions that we are probing or we are investigating. So he talks about IDEC and so on. Now the question is, Chair, what is the difference between his testimony and the testimony of Advocate Mashale? And I think we did discuss about this at some point as this committee, that what is a difference between a public participant and a witness? So I just need to be clarified, Chair, because I'm really confused. This clarity is important so that we have a better insight when we are dealing with witnesses, because the public participants that we have dealt with previously have been afforded an opportunity to make presentation, and if my memory serves me well, some were just reading presentations, which was not made under oath, which was not reliant on affidavits, on sworn statements. Now, Mr. Chetty is a witness, is coming with a sworn statement and is making a testimony, which also relates to some of the terms of reference and also relates to some of the institutions that we are probing. So I just need to get a distinction, Chair. I'm asking this from a genuine perspective because I'm really confused now. What is happening?
Chairperson, the evidence team goes through all the affidavits that we receive from the Secretariat. We received Mr. Chetty's 75-page affidavit yesterday. He had initially filed a one-pager as his evidence as a public participant. He subsequently also attached a number of annexures, which are quite lengthy. I have gone through all of that overnight, and I am prepared to lead his evidence. He is a public participant in my understanding, and how we have dealt with all public participants is that we don't have numerous consultations with them as we do with witnesses as given to us by the committee members, because the list is received from the committee regarding witnesses. However, it does not mean that we compromise all witnesses that come before us. We treat them the same. We consult with them. We go through their evidence. We prepare regardless of the time when we receive their affidavits. Indeed, I can confirm I have gone through his affidavit and I've prepared to lead him this morning.
Okay, let's do this. Because he has said that he wants to meet with you. we are going to afford you that time so that he gets satisfied that when you come back here to start the presentation of evidence, we don't have question marks. So we are going to start with Advocate Masha now and allow you, as it was earlier requested, that you will go and consult with Mr. Chetty, just for the legitimacy of the process, but also to have each one of you satisfied that whatever matter they would have want to raise, the matter is raised. Yeah. Honorable Ngola.
Chair, I'm quite concerned. Was looking also at the evidence of Advocate Mashuha. It's quite, it has got serious volumes. So I'm worried about the approach that we're taking now. If when they are done, the Advocate Mkhwanazi and Mr. Chetty, are we going to interrupt the evidence of Mr. Mashoha, or we're going to take him immediately after?
We're taking Advocate Mashoha and from start to finish. Yes. Yeah. Advocate Mashoha, let's restart the process that I was explaining to you, that you have been invited here to come and help the committee in its oversight and investigative work. We are investigating allegations that were made by the KwaZulu-Natal Police Provincial Commissioner, General Mkhwanazi. Amongst the allegations that he made is the unlawful, number one is the alleged unlawful disbandment of what is called the the political killings task team, otherwise known as the PKTT or NPKTT. Number two, alleged moratorium on the filling of vacancies. And within the South African Police Services, the SAPS. Number three, alleged corrupt relationship between senior leadership within the SAPS and members of the public. And lastly, political interference within the work of the SAPS. In extending this invitation, the chairperson of that ad hoc committee has indicated that you may provide such information to the committee if you so wish, under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act of 2004. Advocate Mashoha, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or even civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to an imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. Which one do you elect, oath or affirmation?
I will take an oath.
Okay, thank you so much. You have elected to take oath. You shall, may you please follow me as I dictate. Please say aye and state your names in full.
I, Molatwa Michael Mashuha,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much, Advocate Mashura. I'm handing over the reins to yourselves, Advocate Mkhize and you. Good luck in the presentation of your evidence.
Honorable Chair, I'm going to lead Advocate Mashukha. Just a few preliminaries before we start, Honorable Chair, honorable members. You would have seen from the affidavit before you that Advocate Mashukha has not disclosed his current position, where he's employed, and also his address. The reason for that, Honorable Chair, honorable members, is that you would also have seen from his affidavit that as a senior state advocate, he had prosecuted a number of high-profile matters, some of which have been concluded and successfully, and where the accused were found guilty and serving prison time. Other matters are still pending, which have now been obviously taken over by his former colleagues now that he's left. In one matter, the well-known or notorious rhino horn matter, where he prosecuted, threats were made to him and the investigating officer in that matter, and the investigating officer was murdered. So he is very concerned about his security and his safety. And in fact, just this morning, his legal team had also raised somewhat disappointment about his security arrangements that they thought would be made with Mr. Romano. So that is the reason, Honorable Chair, that is not disclosed in his affidavit and to this Honorable Committee.
But have those security arrangements been sorted now? Or are you still in the situation you were at the time he raised those concerns with you?
Mr. Masha of the MPA indicates no. So perhaps while Advocate Mashukha is in the relative safety of this chamber, maybe my colleague and Mr. Masha can try and sort it out with Mr. Romano.
But was there a commitment on the part of Parliament to make those arrangements?
I'm not sure, Honorable Chair, Mr. Masha is present. If with your leave, he can address that issue.
Thank you very much, Chairperson. He had made a request when he was requested to come and testify or prepare to testify before this committee. And all that he was provided was a driver, nothing relating to his security was addressed. He brought this to my attention yesterday, and I raised it with Mr. Romano and counsel this morning. And up to now, no indication if the matter is being addressed or not. And to us, that is a concern. Thank you.
It's fine. Let's proceed. We will get Mr. Mpilo as the proceedings go ahead too. and solicit an explanation as to what is happening.
Thank you, Honorable Chair. And again, just before we start, just to contextualize Advocate Mashukha's presence here, he is giving evidence in relation to the again well-known / notorious case of Camildriff, case 1201/2017, which has been referenced in the evidence respectively of Mr. McBride, Mr. O'Sullivan, General Paslani, and that is why this honorable committee, through you, Chair, had requested that the prosecutor in the case, as we know, the matter was struck off the roll in terms of 342A of the Criminal Procedure Act some 7-9 years ago, and has not been re-enrolled. And the honorable committee was rightly concerned why that has not been the case. And Advocate Mashukha is here to assist us in that regard. He was the prosecutor in that matter. Now, this honorable committee wrote to both the previous NDPP, Advocate Patoy, and the current NDPP, Advocate Motibe. There was a letter that was sent to the committee in last year, November last year, by Advocate Patoy. And there's also a letter that was written by Advocate Motibe, and I've asked that it be placed on the desk or be in front of the honorable members, and it's also before Advocate Mashukha. If I may just refer to the first one, dated the 20th of February 2026. Advocate Mashukha, you've got that one? There's two, the one of the 18th. I'm going to deal with that one second. The first one is the 2-pager 2002-2026.
The one that I'm having,
you should have two.
18 February.
Yeah, and then there's another one of the 20th of February.
Yes, I have one.
Is that what that one page?
Oh,
yeah.
yes.
Yeah, and you have it. Thank you. Now, Honorable Chair, Advocate Mashukha, that's the one where, because of course you are no longer in the employ of the NPA, and you're a former prosecutor in the matter, you had to seek permission from the NDPP to testify.
Indeed, so, Chairperson.
And this is the letter from Advocate Motibe, where he says in the third paragraph, I have seriously considered your request and henceforth authorized Advocate Mulatwa Michael Mashukha to disclose the information relating to the criminal case that involved Mr. Paul O'Sullivan, particularly case 1201/2017. Kindly note that the authorization is limited exclusively to disclosure for the purpose of the ad hoc committee. You are reminded that this permission does not constitute a general waiver of confidentiality obligations under the Act, and disclosure remains subject to the restrictions and protections provided therein. Any disclosure made under this authorization must be handled responsibly with due regard to the integrity of the information, the rights of affected parties, and the statutory obligations of the NPA. This authorization is granted solely for the facilitation of the ad hoc committee and shall lapse upon its conclusion. No further disclosure for any other purpose is permitted without the prior written consent of the NDPP. You confirm that, Advocate Mashukha?
I do confirm receipt of this letter, and I confirm that the contents were so received. And in my affidavit, I try as much as possible to ensure that the conditions that were set out in this letter are complied with.
Since your resignation from the NPA in 2024, which you referred to in your affidavit, have you had access to the docket in this matter?
No, I never had access to it.
Good. And then if I may just round this off, there's a letter of the 18th of February 2026, which responds, Honorable Chair, to a number of questions posed by this Honorable Committee. Have you got that one there, Advocate
Yes,
Mashale?
I do have it, Chairperson.
And where Advocate Mutibi refers to the Honorable Committee's letter of 10 February 2026 and the letter written by Advocate Batoy of 17 December 2025. Advocate Mutibi, our current NDPP, says that he has requested the Acting Director of Public Prosecutions within whose jurisdiction this matter resides to provide with a report to address further information. The ADPP has provided a report and the following response. The first question: why was a decision taken by the NPA to hold over the decision to prosecute O'Sullivan until the matter against General Pashlani is finalized? The answer: the ADPP was informed that the senior state advocate assigned the matter prepared an indictment that included charges relating to the contravention of Section 2 of the Prevention of Organized Crime Act, POCA, commonly referred to as racketeering. The POCA requires that racketeering charges require authorization of the NDPP. After due consideration of the said charges, the supervisor held the view that there was insufficient evidence to prosecute on racketeering. The prosecutor was directed to reconsider the appropriate charges. The decision by the prosecutor was thereafter delayed. Mr. O'Sullivan allegedly defamed the prosecutor, and the prosecutor also had to justify allegations made by Mr. Robert McBride at the Zondo Commission. The prosecutor has resigned from the NPA. So, Mashucha, that's a reference to you.
Indeed, Honorable Chairperson.
The ADPP has established that the docket is with the counsel appointed in the civil case and will be assigned to a suitably experienced prosecutor to consider whether to institute a prosecution and whether the case can proceed against O'Sullivan. The second question, whether the report was supposed to be compiled by the prosecutor within 7 days of the judgment did serve before the Director of Public Prosecutions. And Mr. Mashucha, that you're going to deal with in your evidence.
Indeed, so Honorable Chair.
Yeah, this comes from a portion of the magistrate's judgment that the matter is removed from the roll and that the report must be compiled within 7 days.
Indeed, so Chair.
Okay. The answer: it is assumed that the report referred to is the order made by the magistrate during the striking of the matter from the roll in terms of 342A of the Criminal Procedure Act. Section 342A(3)(c) of the CPA provides that the prosecution shall not be reinstated without the written instruction of the Attorney General. That was then the Attorney General, but it's the DPP these days. A report will only become relevant when the delay causing the striking of the matter has been addressed, e.g. further investigation that had to be finalized. In this instance, the DPP was appraised of the court reasons for the striking of the matter. There was no formal report, as it will only become relevant when it is considered to re-enroll the matter. So the concerns, Advocate Mashucha, that's been raised by this Honourable Committee about why the matter has not been concluded or hasn't been re-enrolled, you're going to assist with that in today's evidence.
Indeed, so Honorable Chair, I made an attempt to
place evidence before this committee explaining the delay as well as the 342 capital A C reasons.
So just now, just to focus on your affidavit, we know now that you served as a senior state prosecutor for a long time in the NPA. You served in the organized crime unit, but since 1 September you resigned, and we discussed the reasons why you do not disclose your current employment. Do you just want to give us some overview of your own professional background, which you reference at paragraphs 5 to 8 of your affidavit?
Indeed, so, Honorable Chair, I commenced my employment with the NPA as a prosecutor on the 3rd day of April 2000 at the Magistrate Court, Taung. In 2002, I was promoted to become the Regional Court Prosecutor for the Regional Court in Taung, that is in Northwest. In March 2007, I was appointed as a State Advocate at the Office of the Director of Public Prosecutions in Kimberley, Northern Cape. There my duties are listed there in paragraph 5, which inter alia included dealing with high-profile matters like murder, robbery with aggravating circumstances, rape where victims were murdered. I also dealt with appeals and reviews. And then in 2009, I was appointed as Senior State Advocate at the Office of the DPP Kimberley. And in March 2010, I was transferred to the Office of the DPP Gauteng, Pretoria as a Senior State Advocate at General Prosecutions and subsequently at the Organized Crime Unit. And as a Senior State Advocate, my responsibility included dealing with high-profile matters and complex criminal cases. I also supervised junior advocates. During my employment in the Office of the DPP Gauteng, Pretoria, I was allocated serious cases of police corruption, racketeering, money laundering, cash in transit robberies, murders, taxi violence cases, and targeted assassinations and other cases of a similar nature.
Thank you. Then you describe at paragraph 9 the purpose of your submission to this honorable committee.
Indeed so, Honorable Chair. And I described there that the purpose of this affidavit is to make submissions to the ad hoc committee demonstrating that at a particular point in time, the Independent Police Investigative Directorate, which is IPID, was infiltrated by Mr. Paul O'Sullivan, who was a complainant in a matter that was allocated, that I was allocated to prosecute, as well as her assistant, Sarah Jane Trent.
Then at paragraph 10, you say this, what this matter really, or what's at the heart of this matter is the investigation by the IPID, and then the subsequent threats and intimidation and interference against you and the investigation team and by some of the witnesses, including O'Sullivan, McBride, and some other people. In your submission, you demonstrate interference against you, persons involving, including Mr. McBride. You make submissions about the steps, which is of concern to this honorable committee, that you undertook to re-enroll the case. You make submissions to this committee about the witnesses or some of the witnesses who testified. already before this honorable committee, including O'Sullivan, McBride, General Pashlani, and other witnesses. You respond to allegations made by McBride and one Brigadier Tayani Shlungwani before this committee, and you address some of the related matters.
Indeed, so Chairperson. So in summary, my submissions regarding paragraph 10 will show or demonstrate evidence which will ultimately show that there was a considerable interference with the investigating officers, with me as a prosecutor, which would have contributed to the delay of the Camille Drift case 12/01/2070.
Okay. Then the aspects of your affidavit which follow the mandate of the NPA from paragraphs 11 through to paragraph 22, which is from pages 5 to 8, are more formal matters, the fundamental principles of that guide the prosecution of a matter under the NPA, and also your role as a prosecutor. Do you want to summarize some of that?
Yes, in summary, I would highlight paragraph 16, in terms of which Section 32, subsection 1A of the NPA Act states that a member of the NPA shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith, without fear, favor, or prejudice, and subject only to the Constitution and the law. And paragraph 17, section 32(1)(b) of the NPA Act, which provides that subject to the Constitution and this Act, no organ of state and no member of or employee of an organ of state, nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its or her or his powers, duties, and functions. Paragraph 18, section 41 of the NPA Act provides that offenses and under offenses and penalties, any person who contravenes the provisions of section 32(1)(b) shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 10 years, or both such fine and imprisonment. And I state these paragraphs and provisions in light of what happened during the investigations of the case that I was guiding, and the threats and the interference and the hindering that was occasioned by some of the people involved or accused or suspected in that case.
And you have a comment at paragraph 21 about people like O'Sullivan, McBride, and others who label themselves or call themselves as corruption fighters. What's your opinion?
Yes, I do say that because I have been subjected to sustained interference, insults, and the allegations were that I was captured. In fact, during that time, there was a sustained attack which included interviews, O'Sullivan going to for interviews at different radio stations, Radio 702, Power FM, and different articles were written about me. And ultimately, my name even made it into a book by a certain Jack Paul, where allegations of state capture and corruption were made against me, just because I had made a decision to prosecute Mr. Paul O'Sullivan and some other suspects. As the committee will see later, there was more than sufficient evidence that I relied on to prosecute those people.
Okay. Then from paragraph 23 onwards, you deal with the nature of the matters dealt with in the organized crime unit to which you were assigned. And those clearly, I mean, it's apparent from paragraph 23.1 through to 23.3 that it deals with the most serious of matters. Because it is important to establish your credentials as a senior prosecutor and your views in this matter. Is there anything from under this section, paragraphs 23 to 28, that you want to underline before we move on?
From this, the only important paragraph that I would like to bring to the attention of the committee is the duty of the prosecutor in giving instructions after a matter has been opened, or a case docket has been opened by the police. They do some preliminary investigations, compile the docket, then they bring it to a prosecutor. From there, a prosecutor now starts giving out instructions as to which investigations he would like to be carried out. So
that's the prosecution guided approach.
Yes,
in matters of serious nature like this, also adopted by the PKTT and their team.
Yes, that is the prosecution guided approach, but not the prosecution led.
Is the prosecution led the IDEC approach?
Yes.
And you say there's a difference.
Yes. Indeed, so, Chairperson.
Okay. So in other words, your involvement in the Camille Drift case, this particular case, was quite involved and quite intimate in terms of guiding the investigators and the prosecution of this matter.
Indeed, so after the investigators investigated the matter, collected a few statements, then the docket was taken to the DPP office for a decision. So at the DPP office, it is brought to the attention of a deputy in the DPP office, and then the deputy allocates it to a prosecutor, either a junior state advocate or a senior state advocate. And then by then, because organized crime unit dealt with very serious offenses of which are organized in nature, there were only senior state advocates there. There were no junior state advocates. So before me, there was a prosecutor or a senior state advocate who was allocated.
Masha, if you can just move closer to the microphone.
Thank you. Yes. Before me, there was a senior state advocate who was allocated the matter to deal with. So he, at some stage, resigned, and then I was selected to deal with this matter.
So we move on in your affidavit under the heading the mandate of IPID, and you reference IPID because this will, for you in your affidavit, illustrate or highlight the kind of interference by O'Sullivan, amongst others, in the affairs of IPID. So you set out the mandate of IPID with reference to the Constitution and the IPID Act. Do you want to highlight any particular paragraphs, perhaps 31, 33, and 35,
Yes.
36 and 37 of your affidavit?
Thank you. In fact, I would like to deal extensively with those paragraphs because it is actually the crux of the matter in terms of whether there's always been this question whether Mr. Paul O'Sullivan and Trent were entitled to involve themselves in this investigation, and whether IPID had abdicated its statutory power and duties and functions to a private person. So I would deal extensively. I would start with a paragraph 30, which says that, rather 29, which says section 206, subsection 6 of the Constitution lays the foundation for the establishment of an independent police complaints body, which is to be established by national legislation. Paragraph 30, the Independent Police Investigative Directorate, 2011, Act 1 of 2011, which is referred to as IPID Act, establishes the IPID. Paragraph 31, section 2, subsection D of the IPID Act provides for the object of this act, which inter alia are being to provide for independent, and I would like the committee to underline independent and impartial investigation of identified criminal offenses allegedly committed by members of the SAPS and municipal police services, because in this paragraph, I place evidence before this honorable committee that the IPID investigation at that stage was not independent because it was infiltrated by and led by Mr. O'Sullivan and Ms. Sarah Jane Trent, who were not only not independent and biased, but who had a motive to falsely implicate General Patlani, as we will see in the subsequent evidence that I deal with. And then also you will see that where the section says IPID had to deal with identified criminal offenses allegedly committed by members of the SAPS. Now they extended their own mandate now to include dealing with private citizens who were not members of law enforcement, and even a minister who they had no mandate to investigate him. And then in this affidavit, and I'm at paragraph 32, I demonstrate that the IPID, by permitting O'Sullivan and Trent to lead their investigation into the Patlani matter, runs contrary to the very independence and impartiality the IPID Act seeks to protect and guarantee. And then importantly, at paragraph section 25(1), importantly because it relates to the core of the charges that I preferred against the suspect. Section 25(1) of the IPID Act further provides that no member of the directorate may conduct an investigation in respect of a matter in which he or she has a financial or any other interest which might preclude him or her from exercising or performing his or her powers, duties, functions in an objective manner. So this section deals or refers to a situation where an investigator is related to a person and then involves that person in an IPID investigation, whether that person is related to that person as a friend or as a person who has at some stage helped him financially, or maybe where the person is related to him, where he's a wife to him. He cannot involve those people in an IPID investigation. And then section 25(2) provides that if during an investigation it appears to a member of the directorate that a matter concerns a financial or other interest of that member as referred to in subsection 1, that member must, 1, immediately and fully disclose the fact and nature of that interest to the executive director and withdraw from any further involvement in that investigation. We know that the IPID members, the Patlani task team, had these kind of relations with Sarah Jane Trent and O'Sullivan, where there were favors exchanged amongst and between themselves, the interest being to see General Patlani being removed as a national director or suspended. So the evidence is there. I will set it out during my affidavit and refer to real evidence. Section 33(2) provides that any member of the directorate who willfully discloses information in circumstances in which he or she knows or could reasonably be expected to know that such a disclosure will or may prejudicially affect the exercise or the performance by the directorate of the powers and functions is guilty of an offense. Section 33(4) provides that any member who fails to make a disclosure in accordance with section 25(2) or fails to withdraw in terms of section 25(2)(b), as the case may be, is guilty of an offense. Even the regulations, regulation 10.1 of the regulations for the operation of the Independent Police Investigative Directorate provides that all information, whether verbal or in writing, and all documentation acquired during the course of an investigation conducted in terms of the Act and all records pertaining to any such investigations are to be treated as confidential and may not be divulged to any person outside of the directorate unless authorized to be divulged in the interest of justice by the executive director or relevant provincial head, as the case may be, in writing or an act of parliament. Now, several of the charges against the IPID members related to this contravention of section 33.
And yes, you conclude at paragraph 38 that your submission is that the accused and the suspects in that case have all contravened these provisions that you've referred to.
Indeed so, Chairperson. Now, I also highlight at paragraph 31 the definition of the Prevention and Combating of Corrupt Activities Act.
31 or 39?
39, oh, sorry, Chair, 39. And then section 1 of the Prevention and Combating of Corrupt Activities Act, number 12 of 2004, provides the definition of gratification to include money, whether in cash or otherwise, any donation, gift, or loan, any forbearance to demand any money or money's worth or valuable thing, any other service or favor or advantage of any description, including protection from any action or proceedings of a disciplinary, civil, or criminal nature. We have heard before this honorable committee that Mr. O'Sullivan admittedly made a contribution of 200,000. I think he said 200,000 for the legal expenses of Mr. McBride, and that was during the period that Mr. McBride was suspended. So immediately thereafter, in November, Mr. McBride was reinstated. Same time, O'Sullivan now approaches Mr. McBride and then involves himself in the investigations against the General Patlani. Now, that definition, which says including protection from any action or proceedings and forbearance to demand. So it demonstrates to us that he paid that money for the legal expenses of Mr. McBride as a forbearance for him now being involved in the investigation and exercising the functions and powers of IPID.
So that amounts to gratification.
That amounts to gratification in terms of the act. And then I deal with the other contentious issue of the National Credit Act. Mr. McBride and Mr. O'Sullivan said there's nothing wrong with a person accessing the credit information of private citizens. In fact, that is a very, very dangerous contention by them. So I deal with the National Credit Act 34 and under section 68(1, provision is made there that any person who in terms of this act receives, compiles, retains, or reports any confidential information pertaining to a consumer or prospective consumer must protect the confidentiality of that information and in particular must use that information only for a purpose permitted or required in terms of this Act, other national legislation, or applicable provincial legislation, and report or release that information only to the consumer or prospective consumer or to another person to the extent permitted or required by this Act, other national legislation, or applicable provincial legislation, or as directed by the instruction of the consumer or prospective consumer or an order of a court or tribunal. Now, the Regulation 18.4 of the National Credit Act regulations as amended by the 2015 regulations provides that the prescribed purposes other than for purposes contemplated in the Act for which a report may be issued in terms of Section 70, subsection 2G, are inter alia. One, an investigation into fraud, corruption, or theft, provided that the South African Police Service or any other statutory enforcement agency conducts such an investigation. Two, fraud detection or fraud prevention services. Now, I'm stating this fact because we know from the information, and when we were even able to obtain a statement from TransUnion as to the reason why O'Sullivan and Trent accessed the credit reports of private people. Now, we know that they used this 42.2 reason, fraud detection or fraud prevention, but they cannot, they are liable in terms of the contravention of the Act because there was no complaint of fraud made to them in the first place. Secondly, other than that, there was no fraud and detection. We know that the witnesses whose credit reports were accessed were not suspects. In fact, the witnesses were state witnesses in their in IPID's own investigation. So why did they have to investigate their own state witnesses? And then finally, I referred in paragraph 43 to section 86(1) of the Electronic Communications and Transactions Act, and it relates to also the accessing of the credit information, which says, subject to the Interception and Monitoring Prohibition Act 1992, a person who intentionally accesses or intercepts any data without authority or permission to do so is guilty of an offense. This section, Honorable Chairperson, has now been amended, actually deleted, because of the promulgation of the Cybercrimes Act 19 of 2020. So there's provision for this offense now in the Cybercrimes Act.
Then in conclusion on this section, you underscore the points that you make with reference to that SCA case at paragraphs 44 and 45.
Indeed, so, Chairperson, in that case, I refer to it where it says, and I quote, "The second issue concerns the undesirable fusion of private and police investigations. It appears from the evidence referred to earlier that AIN commanded the resources of the SAPS when it saw fit. The police officials involved readily complied. The SAPS is not up for privatization nor for direction by parties such as AIN. This too is a matter that should be dealt with by the relevant authorities. And on my paragraph 45, lastly, it is not only that the lines between the AIN and police investigations became blurred, but as set out above, police officials acted in two capacities, even going to the extent of doing AIN work whilst on police sick leave. This is untenable and should be investigated by the relevant ministry. So at paragraph 46, I state that I implore this honorable committee to keep all these legal bases, the contravention or rather the provisions of the IPID Act, this case, the National Credit Act. I implore this honorable committee to keep this in mind when we go through the contraventions or the offenses that were preferred against the accused.
Okay, thank you. So now we get to your involvement in the Kameeldrift matter from paragraph 47 onwards. Describe how you came to be allocated the matter in February 2017.
Indeed, so Chairperson, the Kameeldrift matter was initially allocated to a certain state advocate who later resigned. And then in February 2017, the matter was allocated to me by the Deputy Director of Public Prosecutions in the Organized Crime Unit, after a request was made to the DPP himself to assist in securing an advocate due to the commitment of advocates from the Organized Crime Unit. So in the Organized Crime Unit, they normally deal with matters which are more serious, and they take time to study and take through the trial process. So most of the time, you will find that they are all committed, and then they would request that an advocate from outside organized crime be provided. So that is how I was then requested to deal with this docket.
And then at paragraph, once you received the docket, what was your first task?
Yeah, my task was to establish from the contents of the docket whether there is any evidence of the commission of a crime, which is the normal task which prosecutors do when they receive a docket. And secondly, if there is a need for further investigations, in which case then to guide such investigations. As I explained before, as soon as the prosecutor receives a docket, he studies it, he identifies whether there's a need for further investigations, and yes, and then guide such further investigations.
And then at paragraph 50, you highlight the offenses which you had identified that the suspects would have contravened at paragraph 50 after you studied the docket.
Indeed, so Chairperson, I identified that there was intimidation, and the intimidation was the one regarding General Patlane, where he was told that he will be imprisoned, his house will be sold at an auction by O'Sullivan, and he would sell it at, he would buy it at an auction and sell it just like he did with the house of Krecher. That is what he said. and then also extortion against General Patlani. Then there was this contravention of Section 33(5) of the IPID Act, where they presented themselves and acted like IPID investigators, and a conspiracy to commit this offense, and that relates to the two IPID officers who, despite O'Sullivan and Trent acting and pretending like IPID officers, obtaining statements of witnesses like IPID officers, and all what they did. The two IPID investigators did not stop them, or so they allowed them to continue contravening the IPID Act. So they were, I preferred the charges of conspiracy against all of them. And then there's also fraud, where they pretended to Chris Joste, the estate manager, that they are IPID investigators, and they are entitled, using the power of IPID, to access the confidential house plans of General Patlani. So that misrepresentation, I preferred the charges of fraud. And then the extortion of Chris Joste, where they intimidated Chris Joste when he did not want to give them access to the house plans. They intimidated him and said he will be sentenced to 2 years imprisonment, but we know that the 2 years imprisonment was if a person does not cooperate with IPID investigators, not private persons like Paul O'Sullivan and Sarah Jane Trent. And we know that after those house plans were provided by Chris Joste, it is O'Sullivan who took pictures with his phone of the house plans. So in fact, it was O'Sullivan's own private investigation, not an IPID investigation, and they were just using IPID officers as cover. We know that the intention was to show General Patlani that I told you that I'm going to take you to prison. Now here I'm taking you to prison. Because one other factor in this case is that when these investigations were going on, when O'Sullivan and Trent were obtaining this information of the investigations by IPID, they continued taunting General Patlani, sending emails to him that I told you I'm gonna do this and this, and now here you are. And then, yeah, the attempted extortion is against General Patlani, where all these threats were made to him, but obviously he did not succumb to be part of the cabal of O'Sullivan and Trent. So the threats did not result in anything. So there was no advantage in terms of the definitions of extortion that was gained.
So after you considered the totality of the evidence, you identified O'Sullivan, Trent, Tamani, Binang, Mandla Kayesi, Mashlangu, who's late. You identified them as suspects in relation to these charges, and that you describe at paragraph 52.
Yes, in summary, that is the position, Chairperson.
Okay. From paragraph 55 onwards, you discuss the background to your submissions. And in relation to this honorable committee's terms of reference at 56(2), paragraph 56(2), to establish whether any wrongdoing, corruption, or breaches of conduct have occurred within SAPS or any other relevant institution as outlined in the regulations. So that's in summary the context in which you are giving this evidence.
Indeed, so, Chairperson.
Then I think we've discussed this. I don't think you need to spend much time. The honorable committee members have also read your statement. The process of prosecutorial decision-making from paragraph 59, the whole of 59 through to 61. You conclude at paragraph 60, I can confidently state that I applied myself to the obligations set out above, consistently, but more particularly in my handling of the docket in a cumulative matter.
Indeed, so, Chairperson.
Okay. Then you have summarized the charges preferred and the relevant evidence, summary of the facts, which you deal with from after paragraph 61, 62 onwards. Is there anything you want to highlight there?
In fact, Honorable Chairperson, I have already summarized this, so I don't need.
Okay.
I don't think there's a need to repeat it.
Okay. Yeah, just again for ease of reference, the charges of intimidation from paragraph 67, the charge of contravention of 33(5), the IPID Act, and conspiracy to commit such an offense. That's at paragraph 68. Fraud at 69, extortion at paragraph 70, attempted extortion from paragraph 71, contravention of section 18B, small Roman 5 of the of PRECA.
That one I would like to
yes, please
give light on, because indeed this offense, as I say at paragraph 78, this offense is based on evidence of Jooste when on 17 November 2016, O'Sullivan induced Jooste to sign a statement containing false information, and this offense is based on evidence of also of Antoinette Wilhelmina Venter, when on 17 November 2016, O'Sullivan induced Venter to sign a statement containing false information. So what happened in this in the offenses referred to in these two paragraphs was that O'Sullivan, whom we knew that he was a private person and not an IPID member, he drafted statements for the two witnesses, that is Chris Jooste and Antoinette Venter, and then he emailed them saying that this is their statements. And Jooste says in his statement, witness statement, that Mr. O'Sullivan did not even interview him relating to that statement. And Antoinette Venter also says that she was not interviewed. That is why when they received that statement, which said that it was couched in a language that seemed that it is just an innocent draft that demanded that the witness can just look at the statement and amend where possible. But we knew that it was in contravention of the law because, firstly, they were not IPID officers. They had no business with drafting witnesses for witnesses who are IPID witnesses. Secondly, we knew that they acted with intention because there is that issue where they had threatened General Patlane that we are going to imprison you, we are going to take you to prison. And we knew that that was part of them taking Patlane to prison. We knew that before these statements were sent to witnesses, there was intimidation according to Chris Joste. He was intimidated. So O'Sullivan, the inferences that can be made is that Mr. O'Sullivan, after intimidating Joste, knew that he would cooperate to anything that he wanted. And then on paragraph 81 or 80, this offense is based on evidence of Joste when on 18 November 2016, O'Sullivan induced Joste to sign, paragraph 81. This offense is based on Annexure MM4 Commission, which is attached as MM4, when on 23 November 2016, Trent induced Joste to withhold information from a police docket. So Trent sent a WhatsApp, and I will read it from MM4. And
give us the page. It is paginated.
Yeah, it's MM4, Annexure MM4.
Yeah, but the page reference. I think it's 66. Yeah.
Yes, it reads, hi Chris, please send me your name and ID number as appears on your ID for the subpoena. Thanks a million. Already we know that these are private persons, not IPID officers. They do not have any business to subpoena witnesses. Secondly, hi Chris, we are on our way to your offices. Officer Mandla says the CCTV photos are not important and can be removed from the statement. Now, section 18, subsection B(v) of the Prevention of Corrupt Activities Act, PRECA, makes it an offense for a witness or any person to persuade, and persuade is defined there as including cause a witness to remove any part of his statement. This is exactly what Trent was doing. She was instructing, or we can even say requesting a witness to remove a paragraph which dealt with CCTV photos. She had no right to do that. She had no right to interfere there. And in my view, this contravened section 18B(v) of PRECA.
Okay, please pause a little, SC. Honorable Sangwani.
Thank you very much. SC, I'm sorry for interrupting. Please do guide us because this paragraph keeps, these paragraphs keep referring to false information. Are you going to delve into what this false information is? Because it's making it difficult for us to follow. Thanks.
Yes.
Sorry, Honorable Acting Chair. Perhaps if we could direct that question at the witness. The affidavit is quite detailed in that regard. Advocate Mashale, do you want the question to be repeated?
Yes, please.
Okay, thank you. Thank you for that guidance through you, Chair. On paragraph 78, I think 78, 79, and 80, you indicate that I think it's Ms. Trent, Mr. O'Sullivan were inducing the witnesses, Mr. Euster and Ms. Venter, to produce false information. What is the false information?
This false information that was contained in that statement was, maybe I should just give a brief background. After the visit to General Patlani's estate, one of the witnesses called General Patlani and told him that there were some people who said they are from IPID. They were looking for my bank statements and they were asking questions about your house. Then General Patlani called the estate, I think it's Chris Joste, and the manager, and asked him whether there were people who had come there looking for his confidential private information. And Joste agreed. And then he said, but you must not give people like O'Sullivan my confidential information. And then General Patlani sent, because Chris Joste forwarded a picture of O'Sullivan's motor vehicle when they were at the estate to General Patlani. General Patlani forwarded that photo to McBride and said to Mr. McBride, I was informed that a private person was accompanying IPID investigators to the estate. Here is the photo of the car. Ethical investigations are encouraged. After receiving that, it would appear that Mr. McBride then sent the information to Paul O'Sullivan. That is the reason why Paul O'Sullivan made these statements. That is the reason why a case of defeating the ends of justice was opened against the General Patlani. So the false allegations there were those that were contained in that statement, which said that General Patlani encouraged the witnesses not to cooperate with IPID investigators.
You deal with it at paragraph 85, defeating the course of justice.
Indeed so, Chairperson.
No, I think you can also add, the question is mostly based on the further preferred charges against Trent, O'Sullivan, and Mahlangu, where they are alleged to have forced Juste and other witnesses to make false information about the operation of O'Sullivan and the company. So I think the specific question that comes from Honorable Sangon is that what kind of information were they forced to make? What is it that they were told to say about Pahlane or the operation at the estate?
No, this specific charge relates to the statement, the draft statement that was made by Mr. O'Sullivan after McBride informed him, and there we are relying on inference that he would have been informed by Mr. McBride that Pahlane knows what we did, what we were doing at the estate. So O'Sullivan then drafted these two statements for Antoinette Velemina and Chris Joste. And what is important here is that he never even talked to Antoinette Velemina about those allegations. He just drafted a statement and sent it because he knew that he had already intimidated them, especially Chris Joste, on the previous occasion. So he knew that they would comply with his request that they admit that those allegations are true.
Also, yes.
May I continue, Chair? Thank you. Thank you, Advocate Mashale. Perhaps just if highlight or reference some of the paragraphs in your affidavit in relation to crime and injuria at paragraph 87, the charge of perjury at paragraph 89, the personal information illegally accessed and used to what you describe or is quoted as dig up dirt about adversaries at paragraph 93.
Chair, I refer there to exhibit MM6. It contains of 3 pages. In fact, 4. So at some stage during the investigations, General Pahlane made an application for the interdict against the IPID, Paul O'Sullivan, Sarah Jane Trent, and they had to file responding, rather answering affidavits. Now, in those answering affidavits, they made certain false allegations. In fact, there was an answering affidavit and confirmatory affidavits by the others. So the person who answered was Mandla, and the others like O'Sullivan, McBride, and the others just confirmed. So,
and the annexure you referred to is M6?
Yes, it's
and that's from pages 68 to 71, and the selected paragraphs in the answering affidavits.
Yes.
One finds from paragraphs from page 69 through to 71.
Yes. Now MM6 stays there in paragraphs in page 73, paragraph 217. There is no blanket restriction against O'Sullivan. However, if he was not involved in the investigation of, however, he was not involved in the investigation of Patlane. He merely assisted in the preliminary stages by locating certain witnesses who could corroborate the allegations against him. But we knew that this is wrong and this is false allegations that they are, or false information that they are including in a sworn statement. That is one of the reasons that we charged them with a perjury. And also in paragraph 234 of the same affidavit, I also reference it there. It says, I note and confirm that O'Sullivan has indicated that he is not involved in the investigation process undertaken by IPID. I mean, by now, we all know that O'Sullivan was deeply involved in the investigation process undertaken by IPID. Also at page 57, paragraph 148, I confirm that from around 25 November 2016, O'Sullivan had no involvement in the investigation. We know, even from the downloads, that O'Sullivan and Sarah Jane Trent were involved in the investigation up until the 7th of February 2017, 3 days before Sarah Jane Trent was arrested.
Now, this application brought by General Patlane, that was not concluded. That didn't go through its conclusion, didn't go through the court.
I do not know where it ended up, Chairperson.
Okay. In fact, after this application was launched, they were arrested, brought to court. Or rather, Trent, I think, was arrested, and O'Sullivan was summoned. The other two were summoned to come to court. I'm not sure whether.
Yes, I'm not sure. I will find out. But Trent was arrested on the 10th of February 2017.
Yes. I'm not sure if it's apparent from this. I'm looking at M6, the notice, the filing notice, that the date of the issuing of these papers doesn't appear.
It does not appear, but during break, I will give you all that information.
Then paragraph 93, personal information illegally accessed and used to dig up dirt about adversities. You want to, that paragraph 93, you want to mention or refer to those paragraphs?
Yes, paragraph 93, where I refer to when Trent was arrested, a cell phone was seized in terms of section 23(1)(a) of the Criminal Procedure Act, which provides that, I quote, on the arrest of any person, the person making the arrest may, if he is a peace officer, search the person arrested and seize any article referred to in section 20, which is found in possession of or in the custody or under the control of the person arrested. So this is commonly referred to as a warrantless arrest, because normally a search and seizure is done in terms of section 21 of the Criminal Procedure Act, where a normal search warrant is applied for to search and seize and download the information. But now there are two provisions, the one that those that are referred to as warrantless, Section 23(1)(a) is one of the warrantless search and seizure of a cell phone. And at 94, the cell phone was booked into the SAPS 13 and handed to the cybercrime unit for downloading. I was later informed by the investigating team that the cell phone was successfully downloaded, and I was provided with the downloads. In 95, what was found in the download is quite shocking when one considers the fact that McBride and O'Sullivan labeled themselves as corruption fighters. And I indicate there that I do not list the contents of the download of Trent's phone in order to preserve the integrity of the evidence, taking into account the undertaking made by the NDPP to the chairperson that the decision to delay the enrollment of the case is to be reconsidered. I only refer to the content of the download, which serves as evidence of criminal conduct, and those which I referred to, or the facts which I referred to under the charges that I preferred against Trent and others in the draft indictment. And I may add that also the prosecution, draft prosecution memorandum. In 97, I say the following are examples of the types of activities identified in the cell phone. 97.1, there were discussions about Patlani's arrest. 97.2, the inquiry by Trent, who directed to Matlangu regarding the success of the operation at Patlani's place. Now, in this regard, there was a search warrant. I think I followed Nkabinde's evidence before this committee, where he said they obtained, applied and obtained a search warrant to go and search General Patlani's house, but the intention was not to actually confirm the sound system, but it was to confirm what was inside the house. So after the search, Trent and Matlangu did discuss about the success of the operation at Patlani's place. Before the search commenced, McBride leaked the search to the press. In a communication with Trent, Trent asked McBride, who leaked the information to the press, to which McBride replied that it was him. Similarly, after the search was concluded, communication between Trent and Mandla Matlangu showed that they in fact misrepresented to the magistrate that they are going to search for the sound system. They were actually searching the whole house. That's what they said, that they searched the whole house. And that was with the intention of identifying inter alia, the air cons inside the house, the finishes inside the house, to provide to O'Sullivan. And then Mandla even asked Trent, how is Paul taking it? Then Trent said, she's taking it brilliantly. He's even on his way to get a Guinness. So a Guinness is some kind of a beer. So that is the disregard of a person's privacy that they were prepared to go to lengths to violate. Then at paragraph 97.4, I set out that Patrick Johnson causing problems for Mr. McBride on the Marcosin matter. So McBride sent an ID number to Sarah Jane Trent and requested Sarah Jane Trent to get the credit record of Patrick Johnson because Patrick Johnson was the one who was causing problems for McBride on the Makosim matter. So there was apparently a case against the McBride where the witness was Patrick Johnson. So they wanted to deal with him. And then they continued that his false matric certificate must be exposed and suggest that rather Sarah Jane Trent and Paul tip off on the guy than McBride because it's going to be seen as a revenge if McBride tips off. And then I note there that Marco Singh was a witness against McBride in a certain case. And I note there that this is exactly gratification in terms of the preca, because there was what we call a quid pro quo, value for value. So there was this issue of IPID helping or assisting Trent and Paul O'Sullivan to get back at General Patlani in order to have him not or suspended or dismissed. On the other hand, McBride now was getting all these favors. His problems with people like Patrick Johnson were resolved. So this is corruption within the meaning of PRECA. 97.5, Nhleko trying to get rid of me again. There was a discussion of a counter-attack when Minister Nhleko tried to reinstate the case against Mr. McBride. So this also constitutes a gratification because there was plans of a counter-attack. Minister Nhleko's information was accessed by Sarah Jane Trent, and then there was a report on the media that they leaked, which said 30 million rand Nhleko house, alleging that Minister Nhleko had built a house to the value of 30 million rand. And I note there that this is also a gratification as there is quid pro quo, value for value. And then the other gratification was of McBride regarding a polygraph test which was arranged and paid for by O'Sullivan. Now, in this regard, there was a meeting which Nkabinde referred to on the 3rd day of December 2016. This meeting, Nkabinde attended.
Is that the one at Kretsch's house?
Yes, the one at Kretsch's house. After the meeting, I think about a week thereafter, the meeting was leaked to General Mkhwanazi. Now, General Mkhwanazi opened a treason amongst others, a docket. So when they heard about this from the media, they started to panic. I'm saying this in light of the fact that it was said here before this honorable committee that no, the meeting was about a bribe, then later a meeting was about the launch of a book. I mean, if it is an innocent meeting, why do you have to panic and said you are going to counter the allegations by Mkhwanazi, and then they devised a plan in which to say that McBride and Mkhwanazi must go for a polygraph test. But before going to the polygraph test, they invited, rather they arranged that Paul O'Sullivan is the one who is going to provide questions to be asked at the said polygraph test. Fortunately, General Mkhwanazi withdrew from that polygraph test. But here I'm saying that this also constitutes gratification, because other than McBride being gratified by this arrangement, arrangement of a fake polygraph test, other than that, Trent and O'Sullivan are the ones who paid for this polygraph test. And we have invoices in the docket. We have a bank statement that showed that they are the ones who paid on behalf of McBride. And then 97.7, I deal with several instances where Trent was compiling Section 205 requests and receiving the information from IPID members when it was provided by banks and cell phone network providers, despite her not being a member of IPID, which is a contravention of the provisions of the IPID Act. I also refer in 97.8 of several instances where Trent and O'Sullivan accessed credit bureau records of several people, including witnesses against General Patlani. In some of these witnesses, she is requested by Mr. McBride to do that. On one instance, McBride leaks an ID number of Alvin Dupree. Alvin Dupree was Patlani's driver and a witness in their matter. So he leaks an ID of Alvin Dupree to Trent and instructs her to find anything strange on his credit record, which may suggest that he doesn't require. The reason for that, they wanted Alvin Dupree to confirm a draft statement which implicated General Patlani. So Alvin was refusing to confirm that. He said that no, that is false. It must first be amended. So that is why now they wanted to get his credit report, probably in order to have leverage against him. And I note there that IPID had no mandate to investigate private citizens, even a minister. And paragraphs 97.9, I refer to the legislation dealing with the accessing of credit bureau information. And Chairperson, I have already dealt with this before, the national provisions of the National Credit Act.
So just while we pause there, you also deposed to substantially the same matter before the Zondo Commission of Inquiry. You also deposed to a lengthy affidavit, which contains substantially the same allegations, submissions. And we also know that Mr. O'Sullivan had also deposed to an affidavit to the Zondo Commission, essentially contesting your submissions, your allegations.
Yes, what happened is that at the commission, there was a provision that the affidavits by the witnesses must not be supplied to any other person. So we had to send them to the commission. Now, O'Sullivan, when he made his affidavit, he does not only send it to the commission, he sent it also to me, because it contained insults and threats and all those things. So he wanted me to know what he's saying to the commission.
In fact, your affidavit was only released to this committee upon application to the NPA to release your Zondo affidavit and the annexes to us.
Yes, it was released because the Honorable Chairperson wrote a letter to the Department of Justice requesting that they release that to me. They could only release it to me because of the confidentiality consideration.
Okay. Then perhaps if we could just perhaps fast forward to at paragraph 106, you start dealing with the plethora, what you call the plethora of threatening and insulting emails from O'Sullivan, which you regard as interference. You want to highlight some of them?
Indeed, so, Honorable Chairperson, in an email dated 4 November 2017, a copy of which is marked as Annexure MM7, where O'Sullivan stated, amongst others, not Flock, Mlocha, Mabula, Korani, Ngube, Mashuha, or any of the scum out there can survive what is coming. Good will triumph over evil. It always does. Then in an email addressed to me dated 4 November 2017, copied to several people, O'Sullivan inter alia accused me of having meeting with criminals and that I and the Northwest crooks are all guilty of theft of Sarah Jane's phone, unlawfully sending it to Israel. Andries brought it back last Friday and was seen at the airport by one of my people and unlawfully downloading the contents, not only a breach of a constitutional right since there was no such warrant in the first place. Yes, this is also a breach of Act 70, which carries a 10-year sentence. A copy thereof is marked, is attached as MM8.
Yeah, that's at page 74 of the paginated papers, MM8. MM9 you have now provided because it was missing from the statement and the annexes printed yesterday.
Yes, in fact, it was provided today after we were informed that it was missing, but I will provide it.
Yeah, you did.
I will ask copies to be made there.
Okay.
And in an email addressed to Mzinyati is the DPP, dated 15 November 2017, he states, the latest criminal suspect I need to bring to your attention is Advocate Mashuha. A copy thereof, marked as Annexure MM9, is attached. And then in 2 emails addressed to me on 30 November 2017, one of which was addressed in the early hours of the morning at 1 a.m. He inter alia refers to me as a criminal that broadcast for the Patlani family, being dishonest, protecting criminals and being rubbish. In particular, he indicates that he himself will deal with me. And in the second email, he states as follows, people that protect criminals like this are the lowest form of criminals. In fact, he was not referring to me where he said criminal that bought cars for Patlani. I think he was referring to one of the suppliers. And then emails from O'Sullivan to me on 6 December 2017. In the email at 2 p.m. he states, hey, you dishonest prosecutor, why don't you lock these 2 crooks up and the photograph of Ntleko and Patlani was inserted. I'm closing in on all of you. You will rot in jail. So the list goes on and on. But what I want to draw to this committee, what I want to draw to this to the attention of this.
No, I'm just saying that you will rot in jail.
Indeed, so, Chairperson.
Is a phrase familiar with this? Ngabinde, when he was here appearing before us, he also showed us a message with that phrase, you will rot in jail.
Yes, indeed. So, but now the issue here is bad conduct of his. First of all, constituted contravention of Section 32, 1B of the NPA Act, which prohibited anyone from hindering or interfering or threatening a prosecutor. And also, it constituted extortion because remember, I was prosecuting him. So his email were to the effect that because you are prosecuting me, then I'm going. There's one which said that he has gone to Northwest to dig information about me in Northwest, and what he's getting is concerning or something like that. So this is extortion. You are saying just because the prosecutor is prosecuting me, I'm doing a revenge by investigating him. That is exactly extortion.
So, Mr. Mashale, the whole trail of emails and insults that you described continues